We'll also dismiss on Stratton versus Bombin as they have paid.
All right, and I think Miss Bombin's on Zoom, or at least she was earlier. Miss Bombin?
Yes, ma'am.
Okay, again, noting that their attorney has noted that you have paid, and so this case is dismissed.
Okay, thank you.
You're welcome. Thank you.
Like, I just waited 30 fucking minutes for them to send
Oh,
this.
goodbye, because we don't cuss in court. You must have lost your mind. Excuse you. I'm sorry.
I am too, Judge.
Oh my goodness. I know she just done. Okay, anyway, moving on.
Yep. Okay. Go! Will you hand me my screen box?
Now go. Summerfield Realty versus Kristen Quick.
That is for non-payment.
Kristen Quick.
Hello,
Hello, I'm looking for Kristen Quick.
this is her.
Hello, good morning. This is Judge Tanisha Hickerson, and we are on record in evictions court here in Jefferson County, ma'am. So I'm calling you relating to the property at 7508 Garrison Drive, number 16, and that the allegation is that you have failed to pay rent. So,
Hold on.
mhm.
Whoa. I'm on Section 8.
That's okay.
And-
Well, let me tell you what's going on again. So there's an allegation that you have still failed to pay rent. Let me swear you in because you want to, you'll raise your right hand and you swear you in so you'll give sworn testimony. All right, so I have their attorney and a representative on Zoom because this is the day for the hearing. That all parties are supposed to be present in court. So you're telling me again, just because you're on Section 8 does not mean that you still have not failed. So let
You
me
didn't let me finish.
No, so let me hear you out. Go ahead.
So I am on Section 8 and I put in a request to move. My last day, I had a last day of like, hold on, let me pull on my calendar real quick. They got all the paperwork. They knew the day that I was leaving.
Have you left this unit?
Do what?
Have you moved out from this unit?
Months ago.
Okay, well, let me see what is going on. I have their representative. So she's saying, Mr. Benz, that she left months ago. Who's our client representative on this one?
Should be Dion Reese, Your Honor. I guess my first question for the tenant would be, when did she move out and what did she do with the keys?
Okay, so when did you move out, Miss Quick?
I'm looking it up now. Because I wish I would have knew about the hearing.
Well,
I would have brought all my paperwork, you know what I'm saying?
no, you can. Just tell me generally when you moved out. Tell me generally. Like what month?
April, May.
So you've been gone a while. Let's go. Okay, let's.
Yeah.
So I guess the question is, what did she do with the keys?
The next question is, what did you do with the keys? Miss Quick,
I left them there.
where though there?
I text Chris, the maintenance man, but I didn't text. I called him. I was like, "Hey," because so getting a hold of these people.
Just
crazy.
just tell me where you left the keys. You said
I left
there,
them
but
in my
where?
apartment when I moved out.
You didn't turn it into anyone in the office or anything like that?
No, I was not going down there. These people.
Oh,
are
no.
giving me-
I don't get into that. And I'm not saying that you don't have legitimate concerns. It's just not relevant for eviction court. So, okay, so Mr. Benz, her testimony, let me just note that.
I think, let me ask her a few questions, Your Honor, and I think we might be able to dismiss it because, so Ms. Quick, you formerly lived at 70 in Louisville,
Yes, that was my previous address.
and you're saying you moved out in April.
Yes.
She
You
said,
took all your possessions with
Find it
you.
now to give you the exact date.
no, it's okay. She said April or May, and he's just gonna
Right.
ask you the next question, okay? Yeah.
You took
Okay.
all your possessions with you. Anything you left behind can be thrown away.
Yeah, there wasn't anything there.
Okay.
All right. You agree you're not going to go back to the property?
I agree.
And you're agreeing the landlord can have immediate possession?
Yeah.
Thank you.
I think I will dismiss it, Your Honor, and that the key's not being turned in. I think that's another instance of miscommunication for the week.
Right. And not to just to give you some advice, Ms. Quick, anytime you do move out that type of way, you can avoid this type of situation if you can confirm who took the keys and maybe even leave them with an office manager next time. So with that, thank you
Okay.
for your testimony today. The case is dismissed. All right, next is C.D. Woods versus Ashley Cooper.
Andrew Zay for CD Woods, Judge. I don't believe Miss Cooper's on. If I give the court a little bit of background, this was an eviction case. We got judgment on July 1st on kind of a standard agreement type situation. Miss Cooper failed to appear on July 1st. My client was here and represented to me and through me that Miss Cooper was stolen the property. We obtained judgment and immediate possession. Ms. Cooper then filed a motion in late July that was heard early August to vacate the judgment on the basis that she had actually vacated. She didn't present any evidence of that at the time. Judge Langford denied it. She refiled that same exact motion. It was heard late August. Judge Langford heard it again, and it was again denied for the same reason, even though Ms. Cooper had presented new evidence, but again, none of it proved she was out. She has filed this motion a third time, and I should note that on the record, I think it was August 22nd when we were last here,
Right.
I made the statement that if this motion was refiled, I would make a motion for sanctions for frivolous filings. And she went ahead and filed it again. So I have filed a response to her motion, written response, and that also includes a motion for sanctions. For the attorney's fees my clients incurred responding to these motions repeatedly. She's also noticed, I don't know if it doesn't show on CourtNet, but I've also received another motion from her this week, setting another motion for next Friday, on the same motion that's here today. So it's clear, and it's in my written motion, that she's going to continue to do this until she's sanctioned in some way. Judge Langford already admonished her that this motion was not going to go anywhere, and she continues to refile it.
All right, duly noted on the record. I do have your tendered motion and order. From my brief review of it, I don't see any substantive arguments that defendant could make an objection, nor is she present. Again, I'm just asking Ms. Ashley Cooper.
Oh, Judge, if I can add a little bit more, sorry.
That's okay.
Ms. Cooper has also filed a small claims case against my client. I don't object to that. She's she's doing what the court advises tenants to do all the time if they have issues with the property. However, she didn't properly serve it, but I actually hand delivered this motion in response to her yesterday in open court. She filed this motion. She was aware of it, and she has emailed me nothing that's coherent. But she has emailed me, so she is aware of this motion.
Yes. Okay. So she's already been dismissed twice. Today will be the third time. All right, let me just see. And then because I've noticed it's only, not only, I'm so sorry, I don't mean to say that, but for purposes of whether it's a fair amount, it's $1,050 for the, and that you're seeking as reasonable attorney fees incurred in responding to these motions, correct?
That's correct, Judge.
Mr. Chandler, I think I also seen that on August 22nd, that he was officially withdrew, correct?
Yes, he withdrew from the case prior to judgment being entered.
Okay, no, that was before that. I'm sorry. I think that was I seen it as a note, but nonetheless, he's not, it's also the court, and I know it's in here. I just saw it. But I believe she doesn't have any other counsel, correct?
No, she absolutely does not, Judge.
Okay. And there's numerous pages and filings in here, again, also not relevant to her refiling this motion again. And so with that, I'm going to grant your motion again. So just for the record, even though I'm not really sure it's really termed, I don't even know what to call her motion.
Judge, she doesn't really specify, but
No.
it's identical to her previous motions. It's essentially a motion to vacate, is what she's been trying to do.
Well, she's making a motion herself to vacate,
To vacate the judgment. I'm sorry, to vacate.
And that's what I'm saying. So I was like, yes, essentially, okay, so, defendants. And I think that goes all the way back to actually my judgment when I saw it, because I did a judgment with immediate possession, but defendant's motion to vacate, judgment denied, plaintiff's motion. I remember you say it's in this motion, in motion. Is your motion just the response? You said a motion.
My written response contains a motion for sanctions in it.
Correct. So I'm just gonna say it's a motion for sanctions is granted. All right, duly noted. Thank you.
Thank you very much, Judge.
This is a case of Sonia Duckworth versus SIG Properties.
MrzFieldzYT present for SIG Properties.
All right, Ms. Duckworth is present and coming forth. Status, Mr. Zay?
Judge, as far as I know, we're ready to have our trial next week.
All right. Okay, so I note that both parties got the pretrial order. I have not received any pretrial filings at this time. So again, those should be done, especially including the list of witnesses, and any documentary evidence needs to be presented to the court. Do you understand that?
Yes, one of my witnesses, she has cancer, so I don't know if she's gonna make it.
You'll need it. You also need to provide that in written notice to the court.
So I've been sick, so I was gonna come in, but I just came on in. My lawyer is not going to assist me anymore, but I have not received any discovery from Mr. Zane's office, not to my address or anything.
If you had a lawyer, would have went to your lawyer at the time. So,
I still felt like,
but
It's
again,
just
you would have, last time you were present, you said you may have obtained legal counsel. I
Right,
still don't
and
even
then
have
he
any counsel of
decided that-
record.
it's at personal interest, he couldn't take the case.
Okay, so again,
But right now, I'm asking for you to, I would like to file a motion to squash or for order protection. This, I feel like is like discrimination against me to file the discovery because he seen that the details that he wanted was too lengthy for him. So then he decided then he would file a discovery, and I felt like there was retaliation against me. He knows I'm a Section 8 recipient.
you found that it's retaliatory for them
I
to
do not
continue
feel, he
discovery?
feels like
Really?
if he accesses that discovery, that is an attorney, and that's 2,000-3,000 or more, I've already have that here. No one's not going to take this case. So I felt like he did that because he did not want to pay for anything that was on that detail. It was too lengthy. And I'm asking to file a motion to squash or order protection. I feel like he is doing
Okay,
this
I'm gonna stop you there. 'Cause
Yeah,
at
he's-
first
he's-
I
he's
was,
doing
no,
this to
I'm
retaliate
gonna
against
stop
me.
you there.
Yeah.
I'll give him an opportunity to respond, but the court will also have a response to that.
Because
I
there was
think, no,
time that
Ms.
we was in this
Duckworth-
courtroom and
Ms.
he was there
Duckworth,
and you let him
who's
leave.
Who's speaking?
Stop talking.
Who's speaking? I'm not speaking. I do ask that you allow me to finish.
You
I've
didn't let
allowed-
me finish either.
I did.
You
And
did. You
you're-
stopped me.
We're not gonna keep going back
You
and
just
forth.
stop. So
We're
it's
not gonna
okay.
keep
Go
going
ahead.
back and
It's
forth.
okay. Go ahead.
Because at this, you will show respect and decorum to
Y'all
this
ain't
court.
giving me none either.
Are you, again, when I am speaking, I ask that you do not interrupt me. You will give the attorney an opportunity to respond. And understand, once you decide to continue with the case pro se without an attorney, there are matters and structure and decorum you must oblige by, including any pretrial discovery and filings. But I'm gonna give Mr. Zay an opportunity to respond every time he has been here and tried, and that I recall, you both have been cordial and tried to discuss this. This will continue. He is an officer of the court. I will let Mr. Zay respond.
Judge, I'm actually not sure what she's complaining of. If she could clarify, I'm not sure how to respond.
So ma'am, raise your right hand.
That's what I do.
Right. Okay. So is it that you feel like he's retaliating against you because he asked for discovery or he filed discovery?
Yes, the reason why I feel like he did that, he's not asking me for any evidence, any pictures, anything on that detail.
Okay, one moment. Let's just stop there. That's, I think, I'm not, why don't you like, let me know what if anything, what type of discovery has been done in this case?
Judge, they're actually the only discovery that's been done in this case is this was originally a small claims action.
Mm-hmm.
Miss Duckworth and I spoke in the hallway at that time, and I looked through everything she had and made notes of it. But yeah, it's at its core, it's a small claims case. It's just we filed a counterclaim, so we're aware of all of her documentation, and so I never sent her written discovery, so there's nothing to quash.
Yeah, okay. So, and that's what again, I looked through the file. I didn't have what's called written discovery. Where there are, but have asked and they've already looked through your documents. Well, I'm also confused at what it is you're asking me to squash, to stop.
Should I speak now?
Please.
He did not see the judgment where it says, I do not owe them any money. Now, when I called December the 19th of 2023 to Mr. Katie Colin, I asked him to ask Mr. Zane to take the $9.95. I pertained a job at Jack in the Box on Barnstown Road in Louisville, Kentucky, to pay Mr. Zane the $9.95. Mr. Katie Coley says to me, well, do you have it? I said, I can send you a text message of the money now. He says, well, I will call them and ask, and I will let you know.
Who is this individual you're talking
This
about?
is Mr. Katie Colin, who is the landlord of 2013 SIG
Yes, ma'am.
L Properties.
Yes, ma'am.
Was blocked. Realized I had cancer in the left breast, dust mites and all that stuff. When I got to the hospital January 23 of 2024, there was an e-file on the door saying you're evicted.
Okay.
Okay.
We're all past
So
that though.
I do not know why the court was moved from that point, because I came to court, they was like, he's moved it, so there's no court today. I said, what do you mean?
That's all.
They
That's
said
you're
that
talking
he
about
moved it
eviction
to
court,
the
though.
1100 thing, and that's when we got over there. Okay, but no one asked for documents or nothing over there. I just kept coming in back and forth, back and
Let's
forth, back
only
and forth.
start with this case. You're talking.
Now,
You're
this
convoluting.
case is what I'm saying. We were here, we waited so many hours. Mrs. Zane was in the Zoom.
Sure.
I said about 5 minutes about the time you got ready to call my name, Mr. Zane left the screen. Then, oh, sorry, let's stop it. Then you said, well, we'll pass it over. We passed it over. Then he asked for that to be detailed on what I was asking for.
Correct.
So I wrote the
Because you
detail
have,
out.
it's a more
and then that was
definitive
that.
statement. Just
That's
so I'm
what
gonna
I'm saying.
interrupt
I've
you.
been here.
So
and
it's a more
there's times he
definitive
don't do
statement
that.
because it has not really been very clear what it is you're suing for.
He got that.
And so they're disagreeing with whatever that is, and that's why we're going to trial next Friday.
Like, I have been saying it since
Well,
August the 18th
they
of
don't-
2024. I've looked for,
You don't
legal
agree.
No,
So you don't
right.
agree. That's why we go to trial.
No. Okay.
So you have to prove your case at trial.
So I don't have a lawyer, so I have to do it myself.
Absolutely.
Okay. That's
But
what I'm saying.
but we already knew that last time.
So I just
This
let you
is
know
not new
there's
to
no,
you.
I'm gonna have to do it myself. The witness, she could be leaving this world, and the other one is not well. So I'm just here and I'm
But
the
you-
only witness.
It was written in paper. You
Right.
received it. You have to follow the
Right.
instructions on that paper.
So I'm here. I'm the only one here. That's what I was saying to you. That's all I have. It's me.
That's
I'm sorry about the darkness.
go ahead and take it out and
It's
silence
okay.
it.
She knows
No,
I'm
take
here.
it out and silence it. It
I
keeps
did. I tried to
interrupting the court.
I tried to silence it then.
Well, take it out so you can look at it and
Okay, 'cause-
silence it.
I don't want to get in any trouble.
I'm just telling
I
you,
don't
you're
want
not
to
gonna
make
be
too
in
many
trouble for
moves
taking
up
it
here.
out, ma'am.
I'm afraid, and I just didn't want to make too many moves. That's why I want to take it out of my pocket. You told me.
All right, here, and as far as everybody sees, it's a phone.
Okay, so
I don't
go
want
ahead.
you to.
So I'm just gonna represent myself because I have no other
That's
choice.
what I told you that last time.
Okay.
I told you that last time.
Okay.
So that you should not, that's not new to you. That you have been having to represent yourself because you guys cannot reach an agreement. All right, again, you need to have your witness list filed.
That's what.
Filed.
Right.
You have this
She can't.
pretrial order. You received it last time, this.
She can't do it. She's unconscious fighting for her.
You need to do it.
I will do
There's
it.
no attorney for you. This is your
do it.
duty, so you still have this.
I don't have that.
Miss Mary, we'll get you the copy again. You're under a very, very strict, very short deadline. At this point. We're probably, you need to probably read up on how you would like to conduct yourself at trial. The court cannot give you legal
Okay.
advice. Trial is Friday at 1 o'clock. You can always try to reach out to Mr. Zay to see if you can reach a resolution, but that resolution communication goes both ways. And so, no, let me tell you.
They've never asked me to do that.
He did, we were in here
He said-
last time. You quit, so you're
We
not
just
gonna
keep
be,
passing it
I'm
over.
gonna ask you to be truthful with the court, because you were
I
in
am.
here last time. I know that you guys cannot reach an
He
agreement.
just filed a discovery when we were here, June the 6th.
What?
When we came June the 6th, he said, well, he said the details that Ms. Duckworth we asked, we didn't know it was gonna be that lengthy, so we're gonna file a discovery. So
No,
then you said, well, now
no,
we're gonna
you,
go to
you
tree trial.
heard wrong.
Cause I was sick, I couldn't talk.
You heard wrong.
And he
There's-
told me he didn't have my address and I wrote it here.
Right, you got that part, but there's nothing here, already seen all the documents you plan to present. It does not change what they are
Yes,
arguing.
ma'am. Yes, ma'am.
And so
Yes, ma'am.
I am
Okay.
the trier of
Yes,
fact.
yes,
It
ma'am.
will be a
I
bench
do.
trial.
Yes, ma'am.
Mr. Zay, do you have anything to add?
I guess just for Miss Duckworth's benefit and understanding, I did mention I might file or send her written discovery, and I elected not to at the last court appearance. But other than that, Judge, yeah, we'll file everything with the court, and we'll be here Friday at 1 next week.
All right, do you understand that you need to be present at trial Friday at 1 o'clock? Again, I've given you that order again. You'll need to have anything filed that you plan to file. You can write it up, take it to the clerk's office so it gets stamped, it gets put in a file. I have it for review as we all prepare to go forward with trial. Do you understand, Ms. Duckworth?
Yes, ma'am.
That's all.
You're kidding me.
Oh my God.
You have got to be kidding me. What is going on today? This is just, today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in person. We're gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No patience there. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.